Right. So from unit 2, we had this topic, right? Pleading, fundamental rules of pleading, that we did last time. So for pleading, again, we have two other topics like plaint and written statement. Again, separately, their provisions are being mentioned. So we will continue with plaint part today. Then we have, like in plaint, we have return and rejection of plaint. And what are things to be mentioned in the plaint? It's like three different parts we have in plaint. Then we have written statement where we have set of counterclaim. This part is there. Okay, so today we'll continue with return of plaint as well as what all things to be mentioned, like particulars of a plaint. So if we look at like previous year question papers from unit 2, specifically from plaint part, these are the questions which I have seen, like what are the elements, necessary elements in plaint, when it can be rejected, what are the things that need to be mentioned in the plaint, rejection of plaint. From that part there are questions. Okay, and we have like two different things, rejection and return of plaint. Today we will say return, and in the next class we'll say rejection, because there are again more questions from the rejection part that I have seen. I'll try to include some cases also, so that part we will continue in the next class. Okay, now as such, the topic of plaint we have got in institution of suit as well, section 26, where it says how a suit will be instituted. It's by presentation of a plaint. So what is plaint, or what are the things that we need to mention? Everything is given in order 7 of CPC. So if we look at the entire, all the rules given there, it mainly can be divided in like 3 parts. First one is particulars of plaint. What all things are necessary to be mentioned in the plaint? Return of plaint, how or when it will be returned. Rejection of plaint, and then we have these 2 rules which are not that important. So these are the 3 major parts from plaint. Okay, so as such, if we look at the definition part of CPC, plaint is not been defined, but it can be said that it's nothing but like a statement of claim, because the suit will be instituted by presentation of the plaint. So it's nothing but pleading of the plaintiff, right? That's why we say plaint and plaintiff. So whatever claims or whatever is the cause of action for the plaintiff, those things would be mentioned in the plaint. So it is a statement of claim where the plaintiff would mention what are his claims or what are the main cause of action, and other things would be mentioned there. And by presentation of it, suit will be instituted under section 27(6) of CPC as well. So it is a pleading of the plaintiff. What is the cause of action? What are the other details provided by plaintiff for the case to be started with? Order 7 lays down rules relating to plaint. Rules 1 to 8 of order 7 deals with particulars which are needed in the plaint. So these are the ones we have. So plaint is nothing but writing of a cause of action, because sometimes like in pleadings also we have seen that we just want to make everything like very clear that these are only the claims, this is the cause of action, so that court can also frame the questions. What are the questions that the court has to decide, and based on that court can like the case can proceed. It should not happen that party is like going beyond the plaint, just bringing some other new points while the case starts. So that is the reason why, to fix cause of action, ensure that these are only the things, these are the issues that the parties are having, it's needed. In which relief is claimed is set out in detail, or a document by presentation of which the suit is instituted. What is the relief that the person is seeking? Because it might happen that a person is having alternate relief also, that you either take compensation, you either take this relief, that relief. There may be alternate options. You either ask for maybe restoration of property, or you simply take compensation, or you simply ask for performance of contract. So in such cases, it becomes very much important that the type of relief which party is seeking, that also has to be mentioned. So plaint is a pleading that contains all such important things that we need, and as a frame of such plaint. However, substantially a plaint is the expression of cause of action of the party, as in cause of action of the plaintiff, what is the reason or based on what grounds he is going before the court, and what are his main like claims or other things that court has to decide. Now, if we look at rule 1 of this order, right, it talks about particulars which need to be mentioned in the plaint, and it provides for this list. Same ways, these are mentioned over here also, what all things we need to mention in the plaint. So we need name of the court. Ideally, we would see in the plaint that in the court of so and so, right, in the court of city civil court, then the place where the court has been located, that will be mentioned. So name of the court is very much needed, in which the matter is to be tried, where the person wants to like institute the suit, that court name will be mentioned. Take for example, in the matter of civil just junior division, then where the court is located, that place would be mentioned. Name, description, and place of residence of plaintiff. Sometimes we get details like party's name, father's name, age also is mentioned, sometimes place of residence of the party. But that details might not be available for all the defendants. So in such cases, for plaintiff, whatever details you have, you provide that. For the defendant, whatever you have access to, that details you can provide. Maybe you just know name of the parties or something, that you provide. If you have address, if you have father's name or some other details, that also may be provided. Okay, and in fact, this description which has been provided, right, like name of the party, address, residence, father's name, these also help a lot in future as well. Like even when the case is closed, decision has come, at a later stage also, if someone is looking for those case details, right, it becomes very much helpful to confirm that yes, this is only the party against whom the case is being filed. Like in these days, you would see for job hirings or even for banks to provide loans, they would ask for this background verification, like criminal background verification. Is the person having any criminal cases, civil cases, any sort of matter before the court? So in that situations, right, it becomes very helpful because we get the details of parties, right? We can confirm that yes, if there is someone named Rakesh, this is only the Rakesh from so and so state, from this place, father's name is this. So that becomes very helpful for us to decide. So as much as we can, we should provide details for defendant as well. Okay. There was in fact one case of 2020 or 21 where like there was a case filed against a person under this NDPS Act. Like he was not from, like he was not living in India also, he was living in I think US or somewhere, but his parents were from here. So during his holidays, he just came here, and then he like he was charged for like carrying some drugs and stuff. So case was registered against him under NDPS Act. But then case was closed. He was also released that, okay, fine, you were not carrying anything. After that also, because this case was available on in this India Kanun and other websites, right? He was not able to get a job even in US, because whenever they would do a background check, they would get details of this case, which is registered in India. So then he filed a case that this details should be removed because anyways, I was not convicted in this case, right? I was acquitted. So like that he requested, and court also finally like released, asked that, okay, these details should be removed. So in those matters, this information helps a lot, because we may have like a common name wherein it's possible that there may be another person with the same name where a case is registered. So providing these details would help us a lot. Defect of any party being a minor. If someone is minor, that also we see being mentioned, minor represented by so-and-so person, it would be mentioned. The cause of action in the pleading. So what is the main reason or ground why party has approached the court? Is it because for recovery of money? Is it for some declaratory decree? Is it for some injunction? That reason also has to be mentioned, that so-and-so amount was taken from me, it's not being returned, or whatever, it has to be properly mentioned as well. Facts showing that the court has jurisdiction. Also in the pleading, it will be mentioned, like in the plaint, it would be mentioned that because of this thing, so-and-so court, you are the right court having jurisdiction. There would be like one paragraph on that part as well. So which proves jurisdiction of the court. So that also will be mentioned over here. Relieved claim by the plaintiff simply or in alternative. So what is the relief that plaintiff is claiming? Simply and alternatively, can you guess what it might be?
Yes, madam.
Simply and alternatively. Relief also they need to mention. How they will mention? Simply or alternate, like in alternative they would mention. Simply basically means they would straight away say that I want compensation for this certain matter. Or in alternative, as in they would say that if possible, I want specific performance of contract. Like if possible, give me this. But if this is not possible because of any reason, give me that. As in alternative also I'm mentioning. I would prefer this. But if you are not able to give it, at least give this. So I may mention the relief simply or in alternative also. I may mention that in the plaint, because whatever is mentioned in the plaint, only that can be like provided by the court. So it's necessary that I also mention the claim which is there. Where the plaintiff has allowed, set off or relinquished a portion of his claim, the amount so relinquished. It may happen that someone has taken maybe 90,000 rupees from me, and I said that, okay, fine, remaining 10,000 you need not pay, but 80,000 rupees I want. In that case, what I have done is I have relinquished 10,000 rupees that was supposed to be paid. So that also has to be mentioned. That total amount was 90,000, but fine, 10,000 rupees I don't need, but remaining 80,000 I need. So that has to be mentioned over here. Or it may be set off, maybe 90,000 rupees was taken from me, and on the other hand, I have taken 10,000. So there I would mention that I also need to pay 10,000, but just deduct that. So I need to get like 80,000 rupees. Those clarifications also will be mentioned in the plaint itself. The valuation of the suit will also be mentioned over there. Where the suit is for recovery of money, precise amount is needed. If 90,000 rupees has been taken, that amount will be mentioned. So wherever possible, try to mention the exact amount of money which is being claimed by the party. Plus it says where it is about immovable property, like it may be a declaratory decree that I'm seeking for in the court, that I'm asking the court that please declare that I am the lawful owner of this certain property. As in I'm asking for a declaratory decree. I'm asking the court to declare something. In such a case, I need to mention like proper description of the immovable property. Usually we would have some survey number, khata number. We would have some, like demarcation for demarcation purpose. Usually for Gram Panchayat, it happens. They would demarcate it as in like from Ram's house 2 kilometers behind a school, like that also they would demarcate. So whatever is the method of demarcation used, I would apply that, and I will make like mention that in the plaint so that it's very easy to identify the property. So it basically is nothing but description of the immovable property so that it can be identified as well. If the suit is filed in representative capacity, the fact showing that the plaintiff has actual existing interest in the subject matter or has taken steps which may be necessary to enable him to file such a suit. If a representative is filing the case, not the person himself, he need to show that, yes, I'm a person having the right authority to, like represent the party, and I'm accordingly like proceeding with this matter. That also will be done. So these are nothing but particulars that we need to mention in the plaint. But if you look here, right, these are from Rule 2, Rule 3, Rule 4 also I have mentioned. As such, if we talk about Rule 1, it just includes these points. Okay, so this is like the content of Rule 1. Particulars to be contained in the plaint, these are the things. Name of court, description, like that we have till I. After that, we have this Rule 2. Then we have Rule 3. From there also we derive some details that these are also some things that needs to be mentioned in the plaint. So those also should be there in the plaint. So if the plaint is for money suit, a person is claiming some amount of money, in that case, what needs to be mentioned? So Order 7, Rule 2 talks about a money suit. So as a general rule, if the plaintiff is seeking for recovery of some specific amount that I had given 90,000, now I want to get back my amount. In such a case, it's necessary that precise amount, the exact amount is being mentioned in the plaint. It should not be that I had given some amount of money and now I want return of it. That some amount has to be properly specified in the plaint as well. For example, the amount has to be certain, like 10,000 rupees, 90,000 rupees, whatever. But in every single case, it might not be possible that we specify the exact amount. Like it may be something like unsettled accounts or for movables where the value cannot be ascertained with due diligence. Here an approximate amount also I can mention. Take for example, if there is like a partnership which was there between two persons, now the partnership is dissolved and parties want for like settlement of accounts. In that case, they are filing the case that accounts should be settled and I should get my portion of like profits or money. In such a case, it might not be possible to mention an exact amount. So there's some approximate amount they can mention, but if possible or wherever possible, they need to mention the exact amount of money that is being claimed. Okay, so this is relating to money suit. Because how much money party is claiming, that much can be provided by court. Court would not like exceed beyond that. Even in case of this compensations, right? Like claim petition, which are claim application, which are being filed, claiming some amount of compensation. There also court would provide the amount claimed by parties. If at any case court feels that this amount is very less, party should ideally be getting more than that, court may ask the party to make changes in the plaint. That you make these changes, you are entitled to get even more than that. So that may be allowed. Now, there was another topic on interest and costs, right? That party can ask for interest on the like original amount which was there. So where interest is sought in the suit, where party is filing a case for recovery of money, plus he is also mentioning regarding interest on that amount of money. So where plaintiff seeks interest, the plaint shall contain statement to that effect also. How much of interest he is claiming. He should also mention that, yes, on this amount I am claiming interest. This is the amount I am claiming. Is it based on the agreement or contract which was there between parties, or is it based on some commercial transaction? What is the rate of interest? from which date he is claiming, how the amount is to be calculated, all those things need to be specified. So if party wants to claim interest, it has to be specifically mentioned in claim, plus amount, percentage of interest, from where he derived that percentage, is it from the agreement or how, everything has to be mentioned clearly in the plaint as well. Okay. Rule 3 talks about immovable property. So this anyways I have added in that starting part also, that where the subject matter is related to any immovable property, it is important that plaint contains proper description of the property so that it's easy to identify the property. So it may mention the survey number, khata number, the area of the property, or what is the like points, like what is there on its left, right, behind, front, everything will be mentioned. In case it may be identified bounded by boundaries or numbers in a record of settlement or survey, whatever is the method frame, accordingly it would happen. Because for immovable properties, the demarcation thing vary from like state to state. In some panchayats where property is coming under gram panchayat, they would have their own different way of doing it. Manually they would do. In some other registrar office, it would be done electronically. They would have someone would have khata number, someone would have survey number, like that they would vary. So whatever is the method of demarcating the property, that should be properly mentioned in the plaint as well. This part is clear, right?
Yeah.
So if the plaintiff is representing as like a representative, he is like proceeding with the case. In such a case, he need to show that he has some interest in the property, plus he has taken all the necessary steps. Like lawfully, he is the right person to be representing the original person, representing whom he is proceeding with the case. That has to be shown as well. Defendant's interest and liability to be shown. The plaint shall also show that the defendant is or claims to be interested in the subject matter, and that he is liable to be called upon to answer the plaintiff's demand. Like when I'm saying that, okay, someone took 90,000 rupees, I want that money to be returned along with interest. So who is that someone? It needs to be specified. Maybe I would say that so-and-so person had taken this money. Based on this agreement, he had also made the promise. So this person needs to be called before the court so that we can like settle the matter, because he is not returning the money even after sending reminders to him. That means I'm showing defendant's liability over there. The defendant was liable to return me the amount based on this contract, but he is not fulfilling it. He is not even responding to my reminders. So that's the reason why I'm filing this plaint, and he should be called to provide his own grounds. So that also needs to be mentioned in the plaint. Basically, it's like I'm giving the reasons why am I here and against whom I am here. Ground of exemption from the limitation, time of limitation. So whatever is the duration of limitation fixed under Limitation Act, the general rule is that we need to file the case within that prescribed duration only. But in many cases, it may happen that there was a genuine reason as to why I did not approach the court on the prescribed time frame. As in, do I have like a valid ground to ask for condonation of delay or not? If yes, I can file an application for condonation of delay. And in many cases, after looking at the situation, looking at the grounds, courts do allow condonation of delay. So if delay is allowed, I would also mention that on so and so ground, my condonation has been accepted, court has condoned my delay. So on this ground, I am filing this case. So that also has to be mentioned. What is the ground that I am seeking if it is beyond the limitation period? relief to be specifically stated. It's very much needed that I specifically mention the relief, because whatever is mentioned in the plaint, only that much or lesser than that can be provided by the court. That's why in some legislations also we see specific provisions where it clearly mentions or provides power to the court that you can ask parties to make changes. Like if you look at specific relief act, there mostly it has been mentioned that if party is only asking for maybe specific performance of contract and you feel that specific performance of contract is not possible, in that case, rather than simply returning the party without giving anything, you ask them to make changes in the plaint. Ask the party to ask for compensation because specific performance of contract is not applicable. Right? So relief to be specifically stated. Only when I mention the relief that I'm seeking this relief, it may be provided by court, not otherwise. So I may mention that this is the relief that I'm seeking, or the court may say that, okay, fine, you had, sometimes it may happen, okay, that maybe my neighbor was disturbing me by playing loud music all night. And after 5 months of suffering, I finally decided to go to court and file a case. In the plaint, I have mentioned that because of this situation, I am disturbed. So I want an injunction order. I want the court to pass an injunction order and restrict my neighbor from playing loud music in the days to come. And while addressing this plaint, right, while looking at this case, court may feel that only providing an injunction order is not enough, right? Because injunction order court would issue today. What about those remaining 5 months that I have already suffered? So in such cases, court may ask me that, okay, fine, injunction you have mentioned, fine, we would do that. But along with that, in addition to injunction, you also mention about compensation because you are eligible for both these two reliefs. So you also mention for compensation and we will provide that. So that basically indicates that whatever is sought for, only that can be provided, nothing more than that. So court may ask parties to make changes in the plaint also and mention those reliefs as well. Specifically, relief has to be mentioned, whether simply or an alternative, that should be mentioned. And the same rule shall be applied by the defendant as well. So this was one case actually, Rajendra Tiwari versus Basudev Prasad, 2001, this case was decided. This was, I think, some 1990 something case only. It was decided in 2001, where the relief prayed for in the suit is larger relief, and if no case is made out of granting the same, but the facts as established justify granting of a smaller relief, Order 7, Rule 7 permits granting of such a relief to parties. However, under said provisions, a relief larger than one claimed by the plaintiff to the suit cannot be granted. As in, maybe party has said that for this certain reason, I want compensation of 5 lakhs rupees. And while deciding the case, court felt that this matter is not, like of that severity also, that 5 lakhs rupees compensation would be provided. So court came to the conclusion that we can provide 3 lakhs rupees compensation. That is fine because party has mentioned like a larger relief. And while deciding the case, court found that this much of relief is not like justified. Party is not entitled to it. So it's okay if court gives a smaller relief. Court can say that 3 lakhs we are giving, we are not giving 5 lakhs. That is fine. But under the said provision, a relief larger than the one claimed by plaintiff in the suit cannot be granted. If plaintiff has said that I need 3 lakhs rupees compensation, court cannot say that while 3 lakhs, take 5 lakhs rupees. If court feels that, okay, in this case, it can be party is entitled to actually more like amount of compensation, court may ask parties to make changes as well. Like it happens in case of this motor accident cases, where the court may feel that, okay, fine, this is not the right amount of compensation, party has suffered more loss, because there are some methods of calculating compensation also. And the person who has suffered loss might not be that much aware. And if the advocate also by mistake calculated it to be like a lesser amount, court may say that no, you are entitled to claim for this higher amount, but it should be claimed. Otherwise, it cannot be given. Like larger relief than what is mentioned in plaint, that cannot be provided by court. Relief founded on separate grounds, where the plaintiff seeks relief in respect of several distinct claims or cause of action founded upon a separate and distinct ground, they shall be stated as far as may be separately and distinctly. In one plaint itself, there may be more than one cause of action, and for more than one cause of action, party may be seeking more than one relief. So everything has to be properly stated as separately and as distinctly as possible. Previously also we have got this provision that we need to mention everything separately in separate paragraphs so that they can be identified, differentiated. So same thing happens here. If there are more than one cause of action, it has to be properly or separately written so that that can be identified properly. Relief founded on separate grounds. Based on different grounds, you are asking for different types of reliefs. Rule 9 is procedure on admitting plaint, where the court orders that summons be served on the defendant in the manner provided in Rule 9 of Order 5. It will direct the plaintiff to present as many copies of plaint on plain paper as there are defendants within 7 days from date of such order, along with requisite fee for service of summons on defendant. So once court feels that, okay, plaint is fine, we can accept it, suit is instituted, there court will order the plaintiff that you need to provide these many copies because these many defendants are there in your case. We need to inform all those defendants. We need to serve them summons, which that we would attach one copy of plaint as well, so that they can know what are the allegations or charges against them and they can prepare their written statement. So that the plaintiff will have to do. Produce on admitting plaint. Once plaint is accepted, the court would order the parties, like the plaintiff. So this is the first part which we have particulars of plaint, what all things are needed to be mentioned in the plaint and in what situation it would be finally like admitted. That everything is proper, we are accepting it, now it's time to serve summons to the defendant. So this is the part talking about what all things are necessary to be mentioned in the plaint.